sometimes you wonder, what's on my permanent record? Well, what is a permanent record anyway, and what does it mean to you and your job? And George Zoulakis, attorney, it's Baird and Zoulakis in the Lansing area, but he does work all over the state, could warn you, if you looked at his website, you say you only have one chance to get it right. Don't lose your job, your license, or your freedom because you failed to act. And he says, contact our experienced and respected criminal defense attorneys today. And your future is on the line depending how you act. And one lady who's finding that out is a doctor in Okemos who had her medical license suspended earlier this year for DUI. She is suing the state in the Court of Claims to get the incident stricken from her record. I don't know how you do that or if she's got a chance to do that, but George is on the other end of our line. Mr. Zoulakis, welcome back.
Good morning, Michael.
What do you make of this case? Is it possible for her to get something like that stricken from her record, or any of us, really?
Well, people are generally allowed, if they have only one conviction, to seek an expungement after waiting 5 years. But that applies for most felonies, with the exception of capital offenses and some sex crimes. And it also applies for the majority of misdemeanors. The one glaring exception under the law is any traffic offense that's a crime cannot be expunged. So basically, the way the legislation is currently written, she doesn't have an argument from a legal standpoint unless she challenges the validity of the underlying law. So she could claim, for example, that it's unfair to allow somebody who commits an assault, stabs somebody without intent to kill, aggravated assault, beating somebody up, many drug crimes, for example. Those people can expunge their conviction if they only have one. But for a drinking and driving offense, they can't. So she might claim it's just unfair to distinguish drinking and driving offenses, and why can't that be expunged versus, an assaultive crime. And frankly, I think most criminal lawyers would agree with her. But the courts have generally taken the side of the legislature on this and basically said that you have one shot only, except if you drink and drive, you don't get a shot at all.
And you think that's fair yourself?
I don't think that's fair. I think it's constitutionally defective. But generally speaking, if you discriminate between one type of crime and another, there has to be a rational basis for doing this. And, the legislature, I think, probably has taken the side of the Secretary of State, and their theoretical rational basis could be that, once you have a drinking and driving offense, we should all be warned that something like that might happen again. But that also applies to driving with a license suspended and a number of other traffic crimes. I think one could make a similar argument. If you commit an assault, you're an assaulted person, that should not be expunged either, but that is an expungible offense. So bottom line, I don't think it's fair. I think it's a distinction that really is not rational.
Your